Let's take a the judicial branch of California state government, which is contained in Article 6 of the California Constitution. It's the largest judicial system in the country, and there are three levels of courts in our state. Superior Court, the trial courts, Appellate Court, which is the appeals court, and Supreme Court, which is the highest court. The Judicial Council is the rulemaking entity for the judicial branch and has adopted the California Rules of Court, and there are also local rules of court in the 58 county jurisdictions. Article 6 of California's Constitution sets forth the duties and obligations and powers of the judicial branch of state government. So the following is a summary. Section 1 provides the judicial power of the state is vested in the Supreme Court, courts of appeal, and superior courts, all of which are deemed courts of record in the state. Section 2 provides that the Supreme Court consists of the Chief Justice and 6 associate justices, and the agreement of 4 judges present at the oral argument is necessary for a judgment to be rendered. Section 3 provides the legislature must divide the state into districts, with each containing a court of appeal with 1 or more divisions, and that each of those divisions consists of a presiding justice and 2 or more associate justices. And the agreement of 2 justices present at the oral argument is necessary for a judgment. Section 4 provides that in each county of the state, there's a superior court of 1 or more judges, and the legislature prescribes the number of judges and provides for the officers and employees of each superior court. In addition, this section provides that in each superior court, there's an appellate division and that the Chief Justice assigns judges to the appellate division for a specified term. Section 6 of Article 6 provides that the Judicial Council consists of the Chief Justice and 1 other judge of the Supreme Court, 3 judges of the Courts of Appeal, 10 judges of the Superior Courts, 2 non-voting court administrators, and any other non-voting members as determined by the voting membership of the council, and each is appointed by the Chief Justice for a 3-year term. This is pursuant to procedures established by the Judicial Council. 4 members of the state bar are appointed by its governing body for 3-year terms, and 1 member of each house of the legislature is appointed as provided in the rules of the respective houses of the legislature. In addition, the council appoints an administrative director of the courts who serves at its pleasure and performs functions delegated to the council or to the chief justice, other than adopting rules of court administration, practice, and procedure. Section 7 provides that the Commission on Judicial Appointments consists of the Chief Justice, the Attorney General, and the presiding justice of the Court of Appeal of the affected district, or if there are 2 or more presiding justices, then the one who has presided longest, or when a nomination or appointment to the Supreme Court is being considered, then the presiding justice who has presided longest on any Court of Appeal sits. Section 8 provides that the Commission on Judicial Performance consists of 1 judge of a Court of Appeal and 2 judges of superior courts, each appointed by the Supreme Court. 2 members of the State Bar of California who have practiced law in this state for 10 years, each appointed by the governor, and 6 citizens who are not judges, retired judges, or members of the State Bar of California, 2 of whom are to be appointed by the governor, 2 by the Senate Committee on Rules, and 2 by the Speaker of the Assembly. Section 9 provides that the State Bar of California is a public corporation and that every person admitted and licensed to practice law in California is a member of the State Bar, except while holding office as a judge of a court of record. Section 10 provides that the Supreme Court, the Courts of Appeal, the Superior Courts, and the judges have original jurisdiction in habeas corpus proceedings. These courts also have original jurisdiction in proceedings for extraordinary relief in the nature of mandamus, certiorari, and prohibition. Superior courts also have original jurisdiction in all other causes, and the court may make any comment on the evidence and the testimony and credibility of any witness, as in the court's opinion is necessary for the proper determination of the case. Section 11 provides that the Supreme Court has appellate jurisdiction when judgment of death has been pronounced. When appellate jurisdiction in civil cases is determined by the amount in controversy, then the legislature may change the appellate jurisdiction of the courts of appeal by changing the jurisdictional amount that's in controversy. Section 12 of Article 6 provides that the Supreme Court may, before a decision, transfer to itself a cause in a court of appeal. It may, before a decision is rendered, transfer a cause from itself to a court of appeal, or from one court of appeal or division to another. In addition, the Supreme Court may review the decision of a court of appeal in any cause. Section 13 provides that no judgment may be set aside or a new trial granted in any cause on the ground of misdirection of the jury or of the improper admission or rejection of evidence, or for any error as to any matter of pleading, or for any error as to any matter of procedure, unless after an examination of the entire case, the court is of the opinion that the error complained of has resulted in a miscarriage of justice. Section 14 provides that the legislature must provide for the prompt publication of the opinions of the Supreme Court and the courts of appeal, as the Supreme Court deems appropriate, and that those opinions must be available for publication by any person. In addition, the decisions of the Supreme Court and the courts of appeal that determine causes must be in writing with their reasons stated. Section 15 provides that a person is ineligible to be a judge of a court of record unless for 10 years immediately preceding selection, that person has been a member of the state bar or who has served as a judge of a court of record in the state. Section 16 provides that the judges of the Supreme Court are to be elected at large, and judges of courts of appeals must be elected in their districts at general elections at the same time and places as the governor. Their terms are 12 years, beginning the Monday after January 1 following their election. In addition, judges of superior courts are to be elected in their counties at general elections. And for vacancies, the governor fills vacancies in those courts by appointment. A nomination or appointment by the governor is effective when it's confirmed by the Commission on Judicial Appointments. Section 17 provides that a judge of a court of record may not practice law, and during the term for which the judge was selected, he or she is ineligible for public employment or public office other than judicial employment or judicial office. Except that a judge of a court of record may accept a part-time teaching position that's outside the normal hours of his or her judicial position, and that does not interfere with the regular performance of his or her judicial duties while holding that office. In addition, a judicial officer may not receive fines or fees for any personal use. A judicial officer may not earn retirement service credit from a public teaching position while holding judicial office. Section 18 provides that a judge is disqualified from acting as a judge without loss of salary while there's pending an indictment or an information charging the judge in the United States with a crime punishable as a felony under either California or federal law, and if there's a petition to the Supreme Court to review a determination by the Commission on Judicial Performance to either remove or retire that judge. The Commission on Judicial Performance may disqualify a judge from acting as a judge without loss of salary upon notice of formal proceedings by the Commission, charging that judge with judicial misconduct or disability. The Commission on Judicial Performance is required to suspend a judge from office without salary when in the United States the judge pleads guilty or no contest or is found guilty of a crime punishable as a felony under California or federal law. Also, the Commission on Judicial Performance may retire a judge for disability where it seriously interferes with the performance of the judge's duties and is or is likely to become permanent. or the commission can censure a judge or former judge or remove a judge for an action occurring not more than 6 years prior to the commencement of the judge's current term or of the former judge's last term that would constitute willful misconduct in office, persistent failure or inability to perform the judge's duties, habitual intemperance in the use of intoxicants or drugs, or conduct prejudicial to the admission of justice that brings the judicial office into disrepute, or publicly or privately admonish a judge or former judge found to have engaged in the improper action or dereliction of duty. And finally, when the Supreme Court reviews a determination of the Commission on Judicial Performance, it may make an independent review of the record, and if the Supreme Court has not acted within 120 days after granting the petition, then the decision of the Commission is final. Section 18.1 provides that the Commission on Judicial Performance must exercise discretionary jurisdiction with regard to the oversight and discipline of subordinate judicial officers, according to the same standards, and be subject to review upon petition to the Supreme Court. Section 18.5 provides that upon request, the Commission on Judicial Performance must provide to the governor of any state of this union with the text of any private admonishment, advisory letter, or other disciplinary action, together with any information that the Commission on Judicial Performance deems necessary to a full understanding of the Commission's action with respect to any applicant whom the governor of any state in the union indicates is under consideration for any judicial appointment. Section 19 of Article 6 provides that the legislature must prescribe compensation for judges of the courts of record. A judge of a court of record may not receive the salary of the judicial office held by the judge while any cause before the judge remains pending and undetermined for 90 days after it's been submitted for a decision. Section 20 provides that the legislature must provide for retirement of judges of courts of record for age or disability. Section 21 provides that upon stipulation of the parties, a court may order a cause to be tried by a temporary judge who's a member of the state bar, sworn and empowered to act until final determination of the particular cause. And the last section, Section 22, provides that the legislature may provide for the appointment of trial courts of record for officers, such as commissioners, to perform subordinate judicial duties that must be performed.